yes, and for outstanding work in their fields. So in year 2016, I had got the Nari Shakti Award. Otherwise, I am principally a commercial and corporate lawyer. That is my core competency. And for around 6 years, I was also, that is from 2011 to 2017, I was also on a statutory board set up by the Ministry of Environment and Forests. Basically, it was something to do with the environment. So in 2017, my term with that board ended. Otherwise, see, basically, commercial corporate law, this is my core competency. Also employer-employee relations, not hardcore labor law as such, but definitely employer-employee relations, arbitrations, writs. So I have been in practice for 30 years. I've kind of done it all, and I have now narrowed down to the fields that I have mentioned. Now, as an insolvency professional, see, I was initially very, very, I was very, very confused as to whether that is the stream I want to follow, because, that's also a whole time thing. Being an insolvency professional, it requires so much effort, it requires so much time, and yet my core competency otherwise is a lawyer and, like I said, commercial corporate. So see, I thoroughly enjoy the practice of law. I did 2 assignments. One was only as an AR, one was, a full assignment. But then I came to the conclusion that I had in any case thought that I will continue practicing law and do that also. So I came to the conclusion that there is no also about it. If you are an insolvency professional, you have to, it requires a lot of application, and neither is there any also about the profession of law, so you have to focus fully. And like I always say, the law is alive. It's growing all the time. There is so much that happens, so many judgments, jurisprudence growing in various fields. So I then finally decided that what I would do is I would practice under the IBC in addition to, my other fields. So since then, yes, I have been doing considerable practice. I've worked at the Supreme Court, NCLAT, NCLT Delhi. So that has been my journey so far. As everybody here is well aware, you see, NCLAT, of course, it's different now with, it's very, very vibrant, especially because of the chairperson we have, Dr. Ashok Bhushan. NCLT is try. But the thing is, if you don't have enough members, they're running from bench to bench. So I guess once we get more members, then it will meet the promise that it is expected to meet, IBC. So that is as regards my experience.
Thank you so much, ma'am, for sharing that with us. It's a matter of pride for us that we have a Nari Shakti awardee amongst us. And also how you found a middle path, or the best of both worlds, so to say, that you are now practicing under IBC. So, ma'am, I'd like to request you to start the session.
Sure. So I'll just share with the participants, first of all, in fact, how I'm going to do it is, see, there are so many cases. The law is growing. So there is there are many Supreme Court judgments, there are many NCLAT judgments, and they are being rendered all the time. So see, my effort is not going to be to cram in as many. That is not what I'm going to do. I really thought about it. I thought there are many that you will in any case be aware of. So instead of cramming in many, many judgments, I have taken some judgments, some of which are associated with my practice also, and some of which are associated with subjects that I find, aspects that I have recently found interesting and impactful. So that is how I'm going to go about it. Okay, so some of the judgments that you find very, For instance, Rainbow or Vidarbha may not feature in my discussion, but there are others that will feature. That are IBC is a very vast subject, so there are others that will feature, which I'm sure you will find interesting. So with this, I will start my presentation. Yes. Next slide. Okay. So let me first of all start with this Supreme Court judgment, Sunil Kumar Jain versus Sundaresh Bhatt. Some of you may be aware of it also. It's a very well-known judgment. And the topic is very interesting. You see, now the concept of CIRP costs is always engaging the minds of the tribunal, the appellate tribunal, and the apex court. And there are more and more judgments on this aspect. Now, in this case, what had happened was that the employees of the ABG Shipyard Limited, the workers and employees of ABG Shipyard Limited had approached the Supreme Court vis-a-vis their wages and salaries. It was their contention that their wages and salaries have to be included in CIRP costs. And you see at the top what the Supreme Court held, that wages and salaries of only those employees who worked during the CIRP are to be included in CIRP costs. This is the brief. I've briefly captured what the court actually held. So now let me just, expound on this. So I'll read out from my presentation and you can read with me. Dues towards wages, salaries of those workmen and employees who actually worked during CIRP are to be included in CIRP cost and have to be paid in full first, as per section 53(1)(a) of the IBC. So those that have actually worked, their dues are to be paid in full first, as per 53(1)(a) of the IBC, and the other claims towards wages and salaries of workmen and employees shall be governed by section 53(1)(b) and C. So this is what the Supreme Court held. Now, NCLAT had dismissed the appeal filed by the workmen and employees of ABG Shipyard against the order of the NCLT denying any relief to them with regard to their claims of wages and salaries, which they claimed for the CIRP period and prior period. So see, some of these dues were for the CIRP period, some of these dues were for the prior period. NCLT had dismissed, NCLAT also dismissed. So then the appellants filed an appeal against the order of the NCLAT before the apex court. Now the question before the court was whether the wages and salaries of those workmen and employees who had not worked at all. See, this is one of the issues that the court was seized with. There were workmen and employees who had not worked at all during the CIRP period. The Supreme Court considered whether the dues of those employees who had not worked at all during the CIRP period, are these also to be included in CIRP costs? Next slide. Now, what the Supreme Court held was this: wages, salaries of the workmen and employees of the corporate debtor for the CIRP period can be included in the CIRP costs, provided it is established and proved that the resolution professional managed the operations of the corporate debtor as a going concern during the CIRP, and the concerned workmen / employees of the corporate debtor actually worked during the CIRP, then their dues are payable first as per section 53(1)(a) of the IBC. So basically, in the first instance, it has to be proved that the RP actually ran the CD as a going concern. And then this aspect, that the workmen and employees of the corporate debtor actually worked during the CIRP. If that is established, then their dues are payable in full first as per section 53(1)(a) of the IBC. Achha, now the other interesting aspect is, court also held that if the RP has not submitted claims towards the wages, salaries as part of CIRP costs. Suppose the RP has not submitted these claims, still the claims submitted by the workers will have to be adjudicated upon and considered by the liquidator. You see, if the company goes into liquidation, the RP does not submit these claims towards wages, salaries as part of CIRP costs. Nevertheless, the liquidator will have to adjudicate upon the claims of these workers who lodge claims for their wages and salaries. He will have to consider whether these are payable as CIRP costs. He will have to consider and adjudicate whether, you see, for sub period or maybe the whole period, it can't be whole period if the company goes into liquidation, whether the corporate debtor was a going concern, and how many workmen, employees actually worked during the CIRP. That is the moot point. If you actually work during the CIRP, then the dues of those workmen, employees are liable to be paid full as CIRP costs in terms of section 53(1)(a) of the IBC. And a third aspect that also came up for discussion in this case was whether the dues of these workmen and employees, provident fund dues, pension fund, gratuity, as you know, there's a lot of jurisprudence on this also, whether the liquidator can have any claim over those dues. So yet again, the Supreme Court said, no, the liquidator does not have any claim over those dues because section 36(4)(3) of the IBC specifically excludes all sums due to any workman or employee from provident fund, pension fund, and gratuity fund. Excludes all sums due to any workman or employee towards, towards provident fund, pension fund, and gratuity fund from the ambit of liquidation estate assets. So these were the three aspects, but the most important, of course, was that those employees that have actually worked during the CIRP period, their dues will be included as CIRP costs. Next slide, please. Now, this is another interesting Supreme Court case, Maitre Doshi versus Anand Rathi Global Finance Limited. Very briefly, I've stated at top what the Supreme Court held in this case. That CIRP proceedings can be initiated against both corporate co-borrowers, but the recovery of the same amount cannot be made from both parties. Now, see, all of you will be familiar with the concept of debtor and guarantor. Under the Contract Act, the term used is principal debtor. Principal debtor is the party that owes the money to the creditor. Principal debtor is the party that owes the money principally to the creditor, and guarantor is the party or entity that guarantees repayment of the amount owed by the principal debtor, to the creditor. So you must be familiar with this concept, and also you will be knowing that the Supreme Court has already held that you can proceed against the guarantor before initiating any action against the principal debtor. But that is to do with principal debtors and guarantors, or corporate debtors and guarantors. Now, this judgment is not concerned with that. This judgment is to do with co-borrowers, and you will have come across many loan agreements where there is a borrower and there is a co-borrower. Now, this was a bit of a gray area, but this has been conclusively settled by this judgment of the Supreme Court. So please read with me what happened in this case. CIRP proceedings under Section 7, now this is what has been held, can be initiated against corporate debtors who are co-borrowers, but there can be no double recovery of the same amount from both co-borrowers. So see, suppose there is a loan agreement. Two parties together borrow a certain amount from a financial creditor. Suppose some X is borrowed by two parties and there is a default in the repayment of that amount. Now, can the financial creditor try to recover through any action the sum mentioned in the loan agreement from the first borrower, from the borrower mentioned in the loan agreement, as well as from the co-borrower? Obviously not. The same amount cannot be recovered twice. That is what the Supreme Court has held in this case. So CIRP proceedings under Section 7 can be initiated against corporate debtors who are co-borrowers, but there can be no double recovery of the same amount from both co-borrowers. The financial creditor in this case had disbursed the loan to the corporate debtor, and another company had been referred to in the loan agreement as a borrower and pledger. So there was another company which was also referred to as borrower and pledger, since it had pledged shares in the corporate debtor in favor of the financial creditor. So basically what had been entered into were loan cum pledge agreements. So the second entity was the borrower and pledger. It had pledged its shares in the corporate debtor in favor of the financial creditor. Now, this other company was a party to the loan cum pledge agreement in dual capacity. And therefore, the Supreme Court held a Section 7 petition was maintainable against it upon the corporate debtor's failure to repay the loan. You see, in the loan cum pledge agreements, one party was referred to as borrower. The second was the borrower cum pledger. So what the Supreme Court said was that the second party, the second entity, was actually a party to the loan cum pledge agreement in dual capacity. And therefore, a Section 7 petition was maintainable against it upon the corporate debtors, the first corporate debtors' failure to repay the loan. The appeal filed before the Supreme Court was against the order of the NCLAT, whereby the NCLAT ordered that CIRP proceedings under Section 7 could be initiated against both corporate co-borrowers. Now, the respondent was an NBFC and hence a financial creditor that had disbursed a loan to Premier Limited under 3 separate loan cum pledge agreements, according to the appellant, who was a director in Premier Premier Limited also, and in Doshi Holdings. Doshi Holdings was the second company which had pledged shares held by it in Premier Limited in favor of the financial creditor, which was Anand Rathi Global Finance Limited. So they had pledged these shares by way of security for the loan. Now, Premier failed to make a repayment in terms of its agreements with the respondent. Next slide. The financial creditor filed a petition under Section 7 of the IBC to initiate CIRP against Premier. Financial creditor also filed a petition against Doshi Holdings against Section 7 of the IBC for initiation of CIRP in respect of the same claim based on the same documents. So naturally, same claim and same documents. Now, NCLT admitted both CIRP applications, and an appeal was filed against the order of the NCLT, but NCLT dismissed the appeal and upheld the order of admission of the petitions. So, appellant Maitre Doshi filed the appeal before the Supreme Court. Now, what the Supreme Court held was this. It upheld the order passed by the NCLAT. It held that if there is a default, obviously CIRP can be initiated against both borrowers. That is, both corporate persons as corporate debtors. Now, if the dues are, however, the Supreme Court struck a note of caution. If the dues are partly realized from one corporate debtor, the balance may be realized from the other corporate debtor, being the co-borrower. So Supreme Court definitely struck a note of caution, but said, yes, you can initiate CIRP for the same amount based on the same documents against the two co-borrowers, but same amount cannot be recovered twice. I hope I am audible, and if anybody has any questions, you may just ask. Okay, next slide. So this case I want to deal with at some length. Firstly, because it it is regarding an important subject, important for all RPs, that is fee and expenses payable to resolution professionals. And secondly, because I have first-hand experience of this case. Before the NCLAT and before the Supreme Court, I argued this case for this very senior resolution professional, Mr. Devarajan Raman. Okay, so now what was held? What was held by the Supreme Court was that regarding fee, regarding RP's fees, NCLT and NCLAT must not pass ad hoc orders. I mean, just any order must not be passed. And I've excerpted from the Supreme Court judgment. See, basically what had happened was, let me just quickly give you a bit of background, though I've given it later also. Mr. Devarajan Raman's financial and technical bid had been accepted by the Bank of India for a certain corporate debtor. He was appointed IRP. Later, he was confirmed as RP. Now, technical bid accepted, financial bid accepted. So the fee that was payable to him was, I mean, it was agreed fee. While the CIRP of the corporate debtor was going on, the director of the corporate debtor filed an appeal before the NCLAT, and the NCLAT allowed that appeal and set aside the CIRP of the corporate debtor. Now, that is a situation which all of you may face sometime or the other. Now, that was allowed on the ground of limitation. Mr. Devarajan Raman had been working in right earnest. 3 months had elapsed. So the CIRP had been going quite well. Now, but the NCLAT on the ground of limitation set aside the CIRP. NCLAT then said, you go back to the NCLT Mumbai and claim your fee. Go there. Now, Mr. Devarajan Raman went to NCLT Mumbai. He filed an application. Along with the application, he enclosed a sheet in which he gave the detailed working. He gave the detailed working. Now, before the NCLT, Bank of India was also represented. The financial creditor, the appointing authority was also represented. But when it came to fee, without giving any reasoning, the NCLT just reduced his fee. He had given the complete working. He said this is agreed fee. What he was saying was not recorded in the order. You will notice that sometimes orders are very detailed, some orders are very good, but sometimes orders are very cryptic. They are very brief. So that was that. Now, aggrieved by that order, he came to the NCLAT, where I appeared for him. This is when, you see, this was at the height of COVID. Benches had started hearing matters, but it was all virtual. Now, I appeared before the NCLAT. We gave, I think it was a very well drawn out appeal. In 2 minutes, what the NCLAT said was, he only worked for 3 months. So it is sufficient. What NCLT has fixed for him is sufficient. And the appeal was dismissed. No, there was no adequate reasoning. There was nothing about this that the Bank of India had accepted the fee. Nothing at all. Just this much that no, he had worked only for 3 months and the appeal was dismissed. And so we went up in appeal to the Supreme Court. Now see, this I have excerpted from the Supreme Court order, which I will read. Both the orders suffer from an abdication in the exercise of jurisdiction. You are familiar with the meaning of the word abdication. Basically, what the Supreme Court said was that they have not even exercised jurisdiction. How can you pass orders like this? So we were before Justices Chandrachud and Bopanna, and Justice Chandrachud, you will see, he's passed many judgments where he says that reasoning, not only under the IBC, under on several subjects, he's passed judgments where he said reasoning is the mainstay. Reasoning is the mainstay of any judgment. And so he said both orders suffer from an abdication in the exercise of jurisdiction. In the absence of any reasons, either in the order of the NCLT or the appellate authority, it is impossible for the court to deduce the basis on which the payment of an amount of rupees 5 lakhs together with expenses has been found, there's a mistake, has been found to be reasonable. Consequently, an order of remand becomes necessary. We accordingly allow the appeal and set aside the impugned judgment and order of the NCLAT dated 30th July 2020. Similarly, the order of the NCLT dated 7th February is set aside. Miscellaneous application. This is the application that Mr. Raman had filed before the NCLT Mumbai. Miscellaneous application in CP number so-and-so is restored to the file of the NCLT for a decision afresh The NCLT upon remand is requested to expedite the disposal of the MA and to complete the process within a period of 1 month from the date of receipt of certified copy. I'm very happy to share that the miscellaneous application was restored. Mr. Devarajan Raman went back. He's got back the entire fee. Whatever he had asked, whatever had been agreed to initially, that computation sheet that he had got, he's got it all back. So that we succeeded because of this order passed by the Supreme Court. Next slide. So you see, now I've dealt at length with this judgment. I will just share, I'll now share briefly because I've already told you the background. That see, one of the hurdles that we crossed, I mean, we faced when we went to the Supreme Court was that Justice Chandrachud himself had passed a judgment in the matter titled Alok Kaushik versus Bhuvaneshwari Ramanathan and others. He had said, if you see my first para in the middle, I've mentioned this judgment. He had said NCLT can pass orders. They can pass orders regarding the fee of, in this case, it was a registered valuer. So he had said, no, NCLT is fully empowered under section 60, subsection 5, clause C to pass such orders. Whereas my ground was that when it is all agreed between the bank and the resolution professional, how can the NCLT pass just any ad hoc order? That is what I had said before the Supreme Court. But when the argument started, the Supreme Court said, Ms. Sharma, what about our judgment? So then I had distinguished the judgment and I did it successfully. You see, at para 19 of this judgment, Alok Kaushik versus Bhuvaneshwari Ramanathan, the Supreme Court had held that though the CIRP was set aside, so in Devarajan Raman's case also CIRP was set aside, in this case also, the claim of the appellant as registered valuer related to the period when he was discharging his functions as a registered valuer appointed as an incident of the CIRP. NCLT would have been justified in exercising its jurisdiction under section 60, subsection 5, clause C of the IBC. See, basically, there NCLT said, we have been rendered functus officio. I can't pass any order. Now, this gentleman, Alok Kaushik, went to the NCLAT. They agreed with the NCLT. So he went to the Supreme Court, and the Supreme Court in that context said NCLT can pass orders under 65C. When we went, Justice Chandrachud first of all said, what about this judgment of ours? You are saying NCLT could not have passed an order. So then I said, what kind of order? They can pass orders, but what kind of order? They would obviously have to base themselves on what has transpired in this matter. In that manner, I distinguished. I just go to the next slide. So see, I will not deal with this in detail, but regulation 34 of the CIRP regulations is something that I read out. I said, in my case, the COC comprised only of the Bank of India. The COC had fixed the expenses, including my fee. Once that is done, once the COC and the resolution professional have agreed to the fee, all right, NCLT is otherwise empowered to pass orders under section 60, subsection 5, clause C, but can it arbitrarily reduce? So Supreme Court agreed with me. Just go to the next slide. So this I've explained. I will not read in too much detail. We'll just go to the next judgment, which is a very interesting judgment. Just go to the next slide. This also we will skip because this is also about Devarajan Raman only. But all of you, when I share my, my presentation with you later, go to the next slide, please. When I share my presentation, at that time, do read through, because your fee and expenses, I'm sure, is something that is of great relevance to you. Now, this is a judgment that has been passed by the NCLAT principal bench. Pankaj Khaitan versus Jammu and Kashmir Bank Limited on the 28th of February 2023. And I happened to be at the NCLAT when this order was being passed. So I find this very interesting. And why I am sharing this is also because in this case, the Devarajan Raman case argued by me was also discussed at length. So let us look to the facts of this case. What has the NCLAT done in this case? Now, this was regarding the fee of the resolution professional from the date of order of liquidation to the date of appointment of a liquidator. Now, see, in this case, what had happened was a liquidator was appointed late. That kind of thing can happen very often. So, the order that was impugned before the NCLAT, by that order, the adjudicating authority had decided on the quantum of fee and other expenses payable to the resolution professional. So again, it was a fee and expenses matter. Now, in the course of determination of fee and expenses, one, the adjudicating authority made various adverse observations on the conduct of the resolution professional in respect of the insolvency proceedings of Messrs. Kushal International Limited, against which a liquidation order had been passed. So adjudicating authority made there were many allegations against the resolution professional, and adjudicating authority made various adverse observations. And this company, Kushal International Limited, went into liquidation. So the resolution professional, you see, one, in this case, the liquidator was appointed late. The resolution professional was performing some function during that period. And secondly, you see, against the adverse observations that had been made against him by the adjudicating authority, he went up in appeal to the NCLAT. The other thing that had happened in his case was that his fee and expenses had been reduced by the adjudicating authority. Just like in Devarajan Raman's case, fee and expenses reduced. So his had also been reduced, and so he went in appeal to the NCLAT on two counts. One, the negative observations against him, and two, the fact that his fee and expenses had been reduced. But fee and expenses for what? CIRP period? No, it was not CIRP period. Fee and expenses for the period when, despite the company having gone into liquidation, he continued to perform some functions. So he claimed some fee. The fee that he claimed was reduced by the adjudicating authority. Now, it was his case, the case of it was the case of the respondent bank, Jammu and Kashmir Bank Limited, that no liquidator had been appointed at the time of passing the liquidation order. Liquidation order was passed on 28th February 2019. No liquidator was appointed. So, resolution professional had continued only technically. Jammu and Kashmir Bank said that, all right, resolution professional continued, but it was only technical, and therefore the fee claimed by him cannot be allowed, which I think was quite callous also. Any man who is performing some function has to be paid some fee. Next slide. Now, Jammu and Kashmir Bank said he did not perform the duties of the liquidator. But appellant Pankaj Khaitan said, no, I undertook several steps even after the passing of the liquidation order. And then if you read the judgment, he enumerated all these steps in detail. So he enumerated all these steps in detail. Now, adjudicating authority, as already shared by me, made adverse observations against him on the basis of his performance, on the basis of allegations against him, and also reduced his fee for that period when he was continuing to act because liquidator had not been appointed. Now, the short issue for determination was whether adjudicating authority had erred in disallowing the fee and expenses claimed by the appellant and in refixing the same, and whether the negative remarks made by it were in order. Were they proper? Now, what the NCLAT held in this case was as follows: that there is consistency. Now, NCLAT did not find fault with the reasoning of the adjudicating authority. This is, but NCLAT bench 1, principal bench, that is Dr. Ashok Bhushan's bench, but this order has been passed by Mr. Barun Mitra, who is currently sitting with Dr. Ashok Bhushan. So the NCLAT held that there is consistency in the stand of the adjudicating authority, that the resolution professional was never appointed as liquidator. Given this background, the decision of the adjudicating authority in the impugned order dated 22nd March 2022, that the resolution professional not having actually performed the duties of the liquidator and hence not entitled to hefty fees as claimed appears to be reasonable and justified. What the NCLAT said was that he did actually perform the duties of the liquidator. So we will give him some fee, but we will not give him all the fee. You see, the difference between the NCLT order in this case and in Devarajan Raman's case was, one, the adjudicating authority had given a very reasoned order. And secondly, it is not as if there was any agreement between the financial creditor and RP regarding the fee that was to be paid to him for that limited period, when he continued to act only because the liquidator had not been appointed. In Devarajan Raman's case, there was this agreement. So now, what the NCLAT said was the claim amount had been reduced by the AA, but this reduction had not been made arbitrarily, but on the ground that he had not performed the full-scale duties of a liquidator during the stated period. The A noted that no, for instance, A also noted no progress report on liquidation was filed by the resolution professional. Naturally, you see, he was resolution professional. He was not the appointed liquidator. Next slide. So no progress report, no status report. And then one thing that the adjudicating authority noticed was that he could have filed a clarification application before the adjudicating authority regarding his role, regarding the vacuum which arose due to non-appointment of liquidator. So, a resolution professional, what adjudicating authority said was he could have filed an application. He did not even seek any kind of guidance from the adjudicating authority. So he was at best technically continuing in the absence of the appointment of liquidator. And he was merely the custodian of assets of the corporate debtor. So therefore, the adjudicating authority reduced his fee after full reasoning. So what the NCLAT held when Pankaj Khaitan appealed against this order was that the decision of the adjudicating authority is actually in conformity with the decision of the Supreme Court in Devarajan Raman versus Bank of India, since adjudicating authority has given a reasoned order. So remember two things. One, a reasoned order. Secondly, there was no agreement in this case. There was no agreement between the financial creditor and the resolution professional for the fee payable to him for that limited period when he was acting in the absence of a liquidator. But regarding the adverse observations against this resolution professional, the NCLAT held at para 17 we cannot ignore the fact that several steps were effectively taken by him as resolution professional towards the conduct of the CIRP, like making of public announcement, formation of COC, collection of financial records and data of the corporate debtor. Then he held 4 COC meetings in which CIRP progress reports had been furnished. Then he filed a section 19 application. He filed a section 70 application. So basically, what the NCLAT said was, in this scenario, it is not proper to cast aspersions on the conduct of the resolution professional, and the remarks made against him were expunged. So this is the order passed by the NCLAT on 28th February 2023. So again, another order on fee and expenses. Next slide. After this. Now, this is also a recent judgment regarding, December 2022, CA V Venkata Sivakumar versus IDBI Bank Limited. So this is on a limited point. Can the liquidator be removed by the adjudicating authority? So what the NCLAT held was that if you read Regulation 7A of the IBBI Insolvency Professional Regulations, 1, no insolvency professional shall accept or undertake any assignment after 31/12/2019 unless he holds a valid authorization for assignment on the date of acceptance or commencement of such assignment. So see, this point was an issue. This the liquidator in this case did not have a valid authorization for assignment on the date when he accepted the assignment. So one of the things is the NCLAT affirmed that you have to have authorization for assignment. Secondly, regarding removal of liquidator. So as you all are aware, the code does not explicitly state the grounds for removing the liquidator. We are all aware of this, that there are no grounds explicitly stated for removing liquidator. But what the NCLAT has held is that in the absence of specific provisions, sections 33 and 34 of the code and section 276 of the Companies Act. 276 of the Companies Act provides for removal and replacement of liquidators on various grounds. So basically 276, what the NCLAT said was, look at these provisions. Next slide. The NCLAT, this is NCLAT Chennai, they also relied on a judgment of the NCLAT principal bench at New Delhi and said no liquidator has any personal rights to continue as a liquidator. So he has no personal rights. Adjudicating authority for sufficient, if it finds a sufficient cause, if it is valid, if it is just, that has not been captured in, but this is also what the NCLAT said, that its decision must be just. There must be valid reasons. And only then can the adjudicating authority order for a replacement of the liquidator. So you see, what is valid, what is just, all this has not been expounded upon because that would amount to limiting the grounds. But it has been clearly stated that there has to be sufficient cause. There has to be sufficient cause. The justice of the issue should be served by the decision of the adjudicating authority. And the interesting thing is, they also said that adjudicating authority is vested with the power to appoint a liquidator under 33 and 34 of the code. Therefore, the NCLAT fell back on Section 16 of the General Clauses Act, that an authority which can appoint can also remove the person or the entity that it appoints. So this has been held in this case. Because I thought this will be interesting, because whereas there is a lot on IRPs, removal of IRPs, removal of, change of RPs, there are all kinds of decisions on, when even section 27, there is not enough on, removal of liquidators. So here is a decision which was rendered in December 2022. Next slide. No, just go to the next slide. This also, I think this is a continuation. This will have to be deleted. You delete it later. Okay. Now, this judgment, again, I find very interesting. In fact, there seem to be two, you can say almost conflicting, not really conflicting judgments of the NCLAT, but they hold differently. So it is worth our while to consider both of them. Now they are regarding financial contract. They are regarding financial contract, and how is the existence of a financial contract proved? Now, in fact, I happen to be currently dealing with a case in which we are trying to prove an oral for a financial contract. So therefore, both these judgments, I will deal with them at a, at some length. They are both very interesting for me. Okay, so Arun Kumar Agarwal versus ABC Consultants Private Limited. Again, this is a recent judgment, December 2022 of the NCLAT. Now, what had happened in this case was, no, I'm sorry, this is not that judgment. That we will come to subsequently. This is under Section 9, dismissal of Section 9. And this is a recent judgment. This is regarding the dues of an ex-employee. Dues of an ex-employee. So, a gentleman who was at one time an executive director on the board of ABC Consultants Private Limited, he filed this appeal because his Section 9 application filed for his employment dues was dismissed by the NCLT Kolkata bench on 18th December 2019. Now, it's a very interesting case because there was a lot of fight between the employer and the employee, and criminal cases had been filed against the employee. But what did the NCLAT hold? That is what we have to see. Just 1 minute, excuse me. Right. Now, so the appellant was an ex-employee of the respondent. He was promoted as its executive director on 1/4/2014, but his service was terminated 2 years later. Now, see, the respondent had leveled serious allegations of fraud and breach of trust against the appellant and also registered an FIR. I mean, the dispute between the parties was so serious that the employer had filed a police complaint against this gentleman, Arun Kumar Agarwal. And upon that police complaint, an FIR was registered by the police station under sections 420 and 406 of the Indian Penal Code against him, that is cheating and criminal breach of trust. And the employee had also dissociated itself from the appellant by actually publishing a public notice in a newspaper and saying that we have nothing to do with this man, he's not in our employment, he has nothing to do with us. Now, service of the appellant had been terminated on account of his alleged fraudulent activities. There's a word missing. When I share it with you, I'll complete it. Now, the adjudicating authority dismissed the application only on the ground. What did the adjudicating authority do? This Arun Kumar Agarwal filed a Section 9. He was an operational creditor. For his employment dues, he filed a Section 9 petition against ABC Consultants Private Limited, but the adjudicating authority at Kolkata dismissed the application and said, after all, service of appellant was terminated on the ground of fraudulent activities, forgery, etc. And therefore, the amount claimed by him is not operational debt. So they said that his dues are not operational debt because his service was terminated. And actually, there was an employment agreement. There was an employment agreement between the parties, and he had claimed dues under that employment agreement in accordance with the employment agreement. Now, the NCLT also observed that violation of the agreement by either of the parties was bound to, next slide, create a dispute between them, which had actually happened before the termination of service by the corporate debtor. So see, NCLT said, no, there are already disputes. His service has been terminated. That means there are already disputes. And there are allegations of fraud against him, allegations of fraud. So there are already disputes. Now, contention of Arun Kumar Agarwal was that I have claimed under the employment agreement. But his Section 9 was dismissed. Therefore, he filed an appeal before the NCLAT. Now, I have excerpted for you what the NCLAT held. At para 12, I'll read this out to you. It's very interesting what the NCLAT says. The respondent has tried to take advantage of Section 8(2)(a). Respondent is the employer, to contend that the application is not maintainable because of the existence of a dispute before filing of the application. So basically, they tried to say there's a pre-existing dispute. And because of that dispute, they said, no, there's a pre-existing dispute. And because of that dispute, the service of the appellant was terminated. And respondent had to register FIR against the appellant, which is pending trial. So basically, the ABC consultants had said, obviously, there's a dispute. That's why we have lodged a complaint, police complaint. That's why there is an FIR against him. And that FIR is pending. But what the NCLAT said was that a careful reading of Section 8(2)(a) of the code provides that the existence of dispute has to be in respect of the amount claimed. See, just understand that the dispute that existed, I mean, they were alleging fraud, they were alleging all kinds of things. They had leveled a complaint, FIR had been registered, but the NCLAT said, no, the dispute has to be with respect to, actually with respect to the amount claimed, and it is not referable to any kind of dispute, such as the one which is highlighted in the present controversy. So you can't rope in just any dispute. Say, no, parties have disputes. Employer has a dispute with the employee. They said, no, it has to relate to the amount. Then the employee had relied upon a decision in the case of Thothappa Nainar Mohammed Sirajdeen in which the application filed under Section 9 of the code was admitted, but it was challenged before the NCLAT on the ground that there existed a dispute because of a criminal case lodged against the MD of the CD, who had purchased certain material which had no concern with the business of the CD, and the checks issued by him were bounced and a criminal case was lodged against him. So similarly, a criminal case, but in that case, the adjudicating authority had held criminal liability is pending consideration before a court of competent jurisdiction. It is already before a court of competent jurisdiction, but there is no dispute with regard to the supply or quality of goods prior to issuance of demand notice. So see, remember that the dispute has to actually pertain to the subject of the demand notice. It can be the dues claimed against employment or goods or services. Dispute has to be with respect to that. It can't be just any dispute. And of course, all of you are aware that it has to be a pre-existing dispute. So the NCLAT had held in that case that the adjudicating authority had rightly held in this case of Thothappa Nainar Muhammad Sirajuddin that there was no pre-existing dispute. And next slide. Admitted the application. So NCLAT had upheld that admission of application by the adjudicating authority in that case. And in this case, the NCLAT held that from a resume of the aforesaid facts and circumstances, one thing is clear, that the plea of pre-existing dispute has to correlate with the amount claimed by the operational creditor. Or if a suit or arbitration proceeding is pending, then the same should also be related to such dispute. So there has to be a pre-existing dispute, and the dispute has to relate with the amount actually claimed by the operational creditor, whether towards employment dues or for goods, services. So it has to relate with those dues. Now, in this case, the NCLAT held that no dispute had ever been raised by the respondent, that the appellant is not entitled to salary for the period from 1/8/2016 to 16/8/2016, flexi pay basket, basically all the components that he had demanded. So NCLAT said they've never disputed, they've never said that he is not entitled to these dues. They had not specifically disputed these dues. They had just waxed eloquent on this aspect that his services had been terminated. His services had been terminated on account of misconduct, etc. So NCLAT said no, notwithstanding that an FIR had been filed, notwithstanding that it was still pending consideration, notwithstanding that the services had been terminated, if you do not dispute that these amounts were owed, those amounts are then payable. And if you do not pay those amounts, then the Section 9 application ought to have been admitted. So the appeal was allowed. Next slide. Now, this is I started referring to this. Actually, this is one judgment of the NCLAT principal bench. And then there is another judgment, an earlier judgment of another bench of the NCLAT New Delhi. Both these judgments are on a financial contract and how do you establish financial contract. And I mean, they are both very interesting on different facts. So I mean, as we go along, you will see uh, why what has been held in these two judgments is uh, at variance with each other. Now see, in this case, an appeal was Banke Bihari Goyal versus Ambrain India Private Limited and another, NCLAT Principal Bench, 29th March 2022. So in this case, an appeal was filed against the order and judgment dated 12th January 2022 of the NCLT Delhi, by which the application filed by the respondent financial creditor had been admitted. The financial creditor had filed an application under Section 7, claiming an amount of 1.25 crores from the CD with interest. Now, this application was opposed by the corporate debtor. Now, what did the corporate debtor say? The corporate debtor said that no loan had been taken by the corporate debtor from the financial creditor and no written agreement has been produced. See, this was the principal contention. Actually, they were not able to make good this aspect that there was. Basically, they said, all right, amounts may have been disbursed, but it was not a loan. So that's a very specious ground. See, their principal ground was that there was no written financial agreement. There was no written financial contract, no written agreement produced by the financial creditor to show that there was any kind of arrangement between the financial creditor and the corporate debtor with regard to grant of unsecured loan. So they did not deny that an amount had been disbursed, but they said it's not a loan, and they said there is no written agreement. The emphasis was that there has to be a written financial contract. Now, what the adjudicating authority said was BJ Infotech. BJ Infotech was basically the amount had been disbursed by the party called BJ Infotech, and the adjudicating authority said BJ Infotech is a trade name of the financial creditor. Disbursement of the amount has not really been disputed, and so adjudicating authority only on this basis that disbursement of amount has not been disputed admitted the Section 7 application. Now, an appeal was filed. An appeal was filed, and in this appeal, what the appellant said was that there is no written contract for disbursement of the loan. Now, he said, as per the insolvency and bankruptcy, please make a note of this, and you must read this also. As per the insolvency and bankruptcy application to adjudicating authority rules, financial contract as defined in 3(1)(d) includes tenure of debt. See, basically what he said was that a financial contract has to clearly, reveal what the tenure of the debt was, what was the interest payable, and what was the date of repayment. I mean, if there is a loan, surely there will be some tenure for which the sum is loaned, some interest payable, and the rate at which it is payable must be specified, and date of repayment also must be available. Now, what the appellant said was that none of this has been proved by the CD. The CD has not been able to place any written contract on record. This is what was contended by the appellant. Next slide. However, what did the NCLAT say? NCLAT studied Rule 3(1)(d) of the adjudicating authority rules, it is accepted in the judgment. What it says is, financial contract means a contract between a corporate debtor and a financial creditor, setting out the terms of the financial debt, including the tenure of the debt. So the terms have to be clear, the tenure of the debt has to be clear, and after all, interest payable has to be stipulated and date of repayment has to be stipulated. But you will notice that nowhere does it say that it means a written contract. It doesn't say it means a written contract. Now, what the NCLAT held was, I will read out paragraph 5 of their judgment. In the present context, there is no dispute regarding disbursement of amount of 1 crore 25 lakhs. In this context, we have looked into the balance sheet ending 31/3/2018, which has been brought on the record in the appeal itself at page 383. So you see, the balance sheet had been filed by the appellant himself, the aggrieved party. And what the NCLAT said was, we have seen the balance sheet. Now, balance sheet at page 383, under the heading short-term borrowings, contains this mention of loans repayable on demand from others. Now, in the balance sheet itself, this under loans repayable on demand from others, this figured BJ Infra unsecured amount of 1 crore 25 lakhs. So this was shown in the balance sheet itself. So one, the amount was disclosed, loan was disclosed. Then the balance sheet of the corporate debtor, what the NCLAT said, is a clear admission of unsecured loan taken from BJ Infra, which was repayable on demand. Because you see, balance sheet says it's repayable on demand. Now, NCLAT said the submission of the learned counsel for the appellant that there was no contract with regard to the tenure of the loan is belied by the balance sheet of the corporate debtor itself. So there's an admission in the balance sheet, and it says that this loan is payable on demand. Therefore, NCLAT said, one, there is an admission, two, the tenure is clearly provided, and NCLAT also accepted this rule 3(1)(d) of the adjudicating authority rules and said, next slide, there cannot be any dispute with the definition of financial contract and the ingredients which are required to be fulfilled for a contract to be treated as financial contract. But Rule 3D or any of the provisions in the code does not indicate that a formal written contract is necessary. So this is what the NCLAT said, that a formal written contract is not necessary, and ingredients of financial contract can be proved even if there is an oral contract. So the appeal was dismissed. So basically what the NCLAT held was 3(1)(d) of the adjudicating authority rules notwithstanding, a financial contract can be an oral contract. If you are able to prove that a contract exists, then you have established your case. In this case, there was an admission in the balance sheet, and it also said, I mean, the loan was admitted under the head repayable on demand. So NCLAT said that the tenure is also indicated from the balance sheet itself. So this is Principal Bench NCLAT Court 1. Now there is another judgment, but that is different. Though the facts in that case were different, so there it has been held differently. Now what we will do is, let us take, it's around 3:30, so let us take a 10 minutes break. Let us take a 10 minutes break, and after that I will deal with that judgment, which is also NCLAT New Delhi, but a different court. I'll come back to you in 10 minutes, please. Then we'll deal with that judgment. So now, this is another judgment on the subject of financial contract. How do you establish the existence of a financial contract? So, just before we took the break, I discussed the NCLAT principal bench quote one judgment with you. Banke Bihari. Just go back. Just go back. What was the name of the judgment? Go further back. Go further back. Further. Banke Bihari Goyal. Name. Banke Bihari Goyal versus Ambrain India Private Limited and another. Now, a year previous to this, another bench of the NCLAT had rendered another judgment, not a year previous, maybe 6 months. Pavan Kumar, ex-director and shareholder, Vogue Clothiers Private Limited versus Utsav Securities Private Limited and another. Now just see, this was a very different case. Brief facts, but there were some similarities also. So in that case, the disbursal of amount, Banke Bihari case, disbursal of amount was admitted. But what was stated was that there is no written contract agreement. So how can the terms of the contract be inferred? How can the tenure of the contract be inferred? And Rule 3(1)(d) of the application to adjudicating authority rules was referred to. And basically, it was contended that a financial contract has to be in writing. It has to be in writing if all of these aspects, tenure, date of repayment, rate of interest, if all of this is to be revealed, then obviously the contract has to be in writing. But the NCLAT held that no, the contract can be oral. And in that case, there was an admission in the balance sheet. Now, brief facts of this case were that the financial creditor was a non-banking financial services company. It had a certificate of registration issued by the RBI. The financial creditor had granted financial assistance to the corporate. This is very interesting facts. To the corporate debtor in the sum of 6.10 crores between this period. In February 2017, in a span of around 6 days, this much amount was disbursed. Now the corporate debtor was paying interest. It paid interest in the sum of 6 lakh rupees only once on 14th of February 2018 after deduction of TDS. Thereafter, it failed to pay any interest, and therefore the financial creditor, wider notice, recalled the loan. Now, despite this notice dated 27th April 2019, the corporate debtor did not repay the loan, and hence the financial creditor filed an application under Section 7 of the IBC against the corporate debtor. Now, the corporate debtor in its reply resisted the application on various grounds. Now, see, the grounds were similar. Just as in Banke Bihari's case, what the corporate debtor here also said was that there is no agreement actually. The period of loan is undefined. Absence of any agreement for payment of interest at any specific rate. So basically, undefined period of loan, absence of agreement for payment of interest. If there is interest is payable, the rate must be specified, and also the transaction does not fall within the definition of financial debt. So these were the grounds on which this was contested. Now, the adjudicating authority held against the corporate debtor on the basis of section 186 of the Companies Act. It said no, transaction is a financial debt, and it admitted the application under section 7, and it initiated the CIRP. Now, next slide. Now, the appellant before the NCLAT said adjudicating authority has failed to appreciate that the financial creditor did not produce any loan agreement or instrument along with its application under section 7 of the IBC. Now, in the form, see, one of the grounds they took was that in the form in which you file your section 7, it is clearly stated that the financial contract reflecting all amendments and waivers up to date has to be enclosed. So this was one of the grounds taken, that the very format says so. The very format says so. So where is the financial contract? That was one thing. Then the other thing that was contended was that there is no pleading, there is nothing said about the basic terms of the alleged financial contract or financial debt, including what is the date of repayment, what is the rate of interest, what about default, how will default be inferred. So basically the contention was that in the absence of a written agreement, again here what was stated was that in the absence of a written agreement, the financial creditor had failed to establish the financial debt. And like I said, it was contended that the financial creditor has to attach the latest and complete copy of financial contract with the application, reflecting all amendments and waivers up to the date with his application. Then again, in this case also, Rule 3(1)(d) of the application to adjudicating authority rule was referred to, and it was stated that no, the case ought not to have been admitted. And then a judgment of the NCLAT in the case of Sanjay Keval Ramani versus Sunil Parman and Keval Ramani was relied upon, in which it has been held that the mere fact that the company has paid interest and deducted TDS is not sufficient to conclude the existence of a financial debt. So this is what was contended. But you can say that the principal contention was, where is the financial contract? And 3(1)(d) was relied upon. Now, what did the NCLAT in this case hold? Now, at para 13, they said, certain essential conditions are required to be satisfied by a financial creditor seeking to invoke the provisions of CIRP as against corporate debtor. We have taken into consideration section 578 read with section 7 of the IBC. Following essential conditions are required to be satisfied by a financial creditor. Next slide. इधर तो नहीं हो. So now the first is there must be, ये extra हो गया, पीछे जाओ. There must be a disbursal of the loan amount. First condition is there must be a disbursal of the loan amount. 2, such disbursal should be made for a consideration for time value of money. I've excerpted from the NCLAT judgment. And when the debt, whole or any part or installment become due and payable and is not paid by the corporate debtor, means committed default. Now, the NCLAT said the transfer of amount is admitted. The corporate debtor has not denied the same. But with respect to deduction of TDS on the alleged interest amount, they refer to the coordinate bench judgment of the NCLAT in the case of Prayag Polytech Private Limited versus Gem Batteries Private Limited, and said, merely pointing out that TDS was deducted would not be sufficient to conclude that there was a financial debt. TDS can be deducted for various reasons. Now, financial creditor contended in this case, now see, in this case, the financial creditor said that an oral loan agreement is also enforceable. Now, oral loan agreement is enforceable in view of Section 10 of the Indian Contract Act and Section 186 of the Companies Act. So in Banke Bihari's case, their NCLAT said no, financial contract can be oral. In this case also, the contention was that an oral loan agreement can be enforceable. But CD said no. In the absence of a financial contract defined in Rule 3(1)D of the Insolvency and Bankruptcy Application to Adjudicating Authority rules between the corporate debtor and financial creditor, the transaction cannot be termed as financial debt. So on the one hand, the contention is, please look at Section 10 of the Indian Contract Act, Section 186 of the Companies Act. But CD says no, look at Rule 3(1)D. There has to be a financial contract. There the contention is there can be an oral loan agreement. Screen share. Just one moment, there's a bit of a problem. Okay, next slide. Now, again, the NCLAT referred to the judgment in Prayag Polytech and said in that it has been held as regard relying on Section 10 of the Contract Act 1872. In our view, IBC is a complete code in itself. Section 238 of the IBC has overriding effect on provisions inconsistent with IBC. The financial contract is defined in Insolvency and Bankruptcy Application to Adjudicating Authority rules. Rule 3(1)D requires setting out the terms of the financial debt, including tenure, etc. We find that the appellant has failed to show any record showing financial debt to be there. As such, we are unable to find any fault in the impugned order while rejecting Section 7 application. So see, with respect to Section 10, with respect to relying on Section 10, NCLAT said no, the IBC is a complete code and we will look at 3.1D. But they did not specifically say 3.1D requires a written contract. What they said was, we find that the appellant has failed to show any record showing financial debt to be there. As such, we are unable to find any fault in the impugned order. So it was therefore held that, again, that a clear financial contract is a must, which must set out the terms of the financial debt, including tenure of the debt, interest payable, date of repayment. But this issue was not affirmatively, ruled upon, a written contract or no written contract. But they said there has to be a financial contract, and they said no. When the IBC is a complete code, we will not look at Section 10, we will look at Rule 3.1D. So they simply said that there has to be a contract, and the tenure of the debt, interest payable, date of repayment has to be clearly revealed. In the absence of such a financial contract, the appeal filed by the corporate debtor against admission of the Section 7 application was allowed. See, in Banke Bihari's case, it was dismissed. Here, the appeal was allowed even though the disbursal of funds was admitted. So these two cases seem to be somewhat at variance with each other. And why I find both of this very interesting is, in fact, I have recently filed an appeal. You see, screen sharing. I have recently filed an appeal. In that case also, our contention is that there is no financial contract. There is no written financial contract in that case. But because of Banke Bihari's case, which is the later case, you see, later law is what we will be binding. Because though it doesn't seem to take into account, I mean, it has not dealt with the earlier case, but still, oral financial contracts have been upheld. So our challenge in the appeal that I have filed, there I've said there is no oral contract, there is no written contract. And there we will have to demonstrate that there is no oral contract. We'll also have to speak a little on how can an oral contract be proved. So that's why I wanted to share both these judgments, because I'm dealing with these currently. And this is an interesting aspect. You may come up, you may have to also deal with similar aspects during your career as IPs. Next slide. Okay. So now we come back to the Supreme Court. Now, again, this is a well-known judgment. You may know of it also. State Bank of India versus Krishi Dhan Seeds Private Limited. An unqualified acknowledgement of debt in the balance sheet extends the period of limitation for filing of the CIRP. As you know, there's been a lot of debate on this. A lot of law by the NCLT, by the NCLAT, 5-judge bench of the NCLAT, and then, of course, by the Supreme Court. Now, this is yet another judgment by the Supreme Court. Now, of course, the law is well settled. So you must be aware of Section 18 of the Limitation Act. 18 of the Limitation Act, which says that an acknowledgement in writing, which is rendered within the 3-year period, after default, after cause of action for suing accrued to the aggrieved party. So an acknowledgement which is rendered within the 3-year period, within the period of limitation, will extend limitation. This is what section 18 of the Contract Act says. Now, what the Supreme Court has held is that if there is an acknowledgement of debt in the balance sheet of the corporate debtor, and it is an unqualified acknowledgement, no reservations, without any qualification, can furnish a legitimate basis for determining whether period of limitation stands extended, so long as, like I just said, so long as the acknowledgement was within a period of 3 years from the original date of default. Now, what had happened in this case was NCLAT had rejected an application filed by the State Bank of India under Section 7 of the IBC against the corporate debtor. Now, the respondent in this case had availed of credit facilities from the appellant, and the outstanding amount under the credit facility was a sum of 102.4 crores. However, the respondent failed to honor the terms of the credit facilities and defaulted in repayments. Therefore, the respondent's account with the appellant was classified as NPA on 10th June 2014. Next slide. Now, I think there's a slide missing. Go back. So NCLT had, no, go back. NCLT had rejected. NCLAT also rejected. I'm sorry, that's missed out. I'll note it in my. So these are the facts that the respondent had availed credit facilities from the appellant, but failed to repay. Now, after the NCLAT also rejected the appeal filed by the State Bank of India on the ground of limitation, because they said, okay, NPA, it was classified as NPA on 10th June 2014, and you are filing in 2018. This is what happened before the Supreme Court. Now, next slide. The Supreme Court enumerated the entire sequence of events in its judgment. It said, appellant sought recourse to the SARFAESI Act and Recovery of Debts Act while continuing to engage in negotiations with the respondent. Now, a letter was issued by the respondent to the appellant on 19th January 2016. 19th January 2016, offering a one-time settlement of 61 crores. This was conditionally accepted by the appellant. However, the respondent by a letter of 18th September downgraded and said 40.6 crores. This was refused by the appellant. So the State Bank had filed an application under Section 7 on the ground that there was a default on the part of the respondent in repaying the financial debt of 189 crores as on 30th June 2018. So, while rejecting the application under Section 7 of the IBC on the grounds of limitation, NCLT had observed that the respondent's loan account was declared as NPA on 10th June 2014, while the proceeding under Section 7 was instituted on 19th September 2018, that is beyond a period of 3 years from the date on which the right to apply accrued. Please remember, now there's a lot of law on this also. The right to apply doesn't accrue when the account is declared as NPA. It accrues when the default occurs. The default obviously occurs sooner. I need the screen sharing. Default obviously occurs sooner. So NCLT said that no, you have applied, your NPA was in 2014, you have applied in 2018. This is beyond a period of 3 years from the date on which the right to apply accrued. Now, NCLAT also held against the appellant. Then there was a further appeal, and what did the Supreme Court say? The Supreme Court observed. So in this case, there was also an acknowledgement in the balance sheet. Acknowledgement in the balance sheet. And Supreme Court, see, this judgment is known for this observation. Supreme Court said if there is an unqualified admission, acknowledgement in the balance sheet, Section 18 of the Limitation Act will come into operation. This acknowledgement can be relied upon. Honey, screen sharing. Just one moment. There's a problem in screen sharing.
No issue.
It's not showing here, not showing on my screen. Can all of you see the screen? I mean, is the screen sharing visible to you?
No, ma'am, it's not visible.
Okay. It's now coming back.
Yes, it's
Okay.
visible now.
Now it's fine.
Yeah. So see, Supreme Court said Section 18. Section 18 comes into operation, Section 18 of the Limitation Act, if there is an acknowledgement without qualification in the balance sheet. And it is made within the 3 years period, that is within limitation. It is made within the 3 years period from the original date of default. Next slide. So, Supreme Court said that this acknowledgement extends the limitation for filing an application under Section 7 of the IBC. And with this clarification, it allowed the appeal and set aside the orders passed by the NCLAT and NCLT. So now there's a lot of, I mean, this position is quite clear. There's a lot of law on this aspect now. Next slide. Now, this is something recent. It is NCLAT. It's an NCLAT judgment. Abhay Narendra Lodha versus Bank of Baroda. And again, this is also on the aspect of limitation. I thought it will be interesting to juxtapose it with the State Bank of India judgment. So in this case, an application under section, basically what was held was that an application under Section 7 of the IBC can be initiated when a default has occurred. And there is no such provision that the occurrence of default has to be taken into account from the date of the NPA. I just told you that in that case, NCLT said your NPA was, I mean, the declaration of NPA was June 2014. So they took that as the starting point. But in this case, it was clarified that Section 7 can be filed when a default has occurred and there is no such provision that the occurrence of default has to be taken into account from the date of declaration of NPA. So the definition of the word default was looked at. So default is defined in section 3, subsection 12 of the code, and it means a non-payment of debt, whole or any part or installment, when non-payment of debt when whole or any part or installment of the amount of debt has become due and payable and is not paid by the debtor or the corporate debtor, as the case may be. So whenever a debt has become payable or a part of a debt has become payable as per the arrangement between the parties and it is not paid, a default is stated to have occurred. Now, it was also held at para 29 of this judgment that the Honorable Supreme Court in various decisions has categorically held that trigger for initiation of CIRP by a financial creditor is the date of default on the part of the corporate debtor, that is actual non-payment of debt repayable by the corporate debtor when a debt has become due and payable, and not the date of the NPA. With regard to the aforesaid finding, a beneficial reference is drawn in the matter of a Lakshmipat Surana versus Union Bank of India. So this is a Supreme Court judgment where this was affirmatively stated, whereby the Honorable Supreme Court held that the date of default is to be reckoned for the purpose of initiation of CIRP and not the date of the NPA. You don't initiate CIRP from the date of the NPA. You initiate CIRP from the date of default as defined in section 3, subsection 12 of the code. So, Abhi Narendra Lodha versus Bank of Baroda, NCLAT has relied on the judgment of the Supreme Court in Lakshmipat Surana versus Union Bank of India. And that is also what has been stated in the earlier judgment, State Bank of India versus Krishidhan Seeds. Next slide. This is the last judgment. So with this, I come to the last judgment that I'm going to be dealing with. Though again, this is a well-known judgment, but it is interesting. Therefore, I thought I must include that in my presentation. New Okhla Industrial Development Authority versus Anand Sonbhadra, Supreme Court. Now, what the Supreme Court held was, the Noida Authority went to the Supreme Court with a very interesting proposition, that they are a financial creditor under the IBC because they have leased plots. They have entered into lease agreements and therefore they are financial creditors and not operational creditors. But what did the Supreme Court hold? The Supreme Court said no. Noida Authority is not a financial creditor because leasing a plot with restrictive covenants and clauses is not tantamount to financial lease. So under the lease in question, the lease was examined at length. Under the lease in question, there was no disbursement of any debt, that is loan amount, or any sums by the appellant to the lessee. What was stated was no disbursement of debt, loan amount, any amount by the appellant to the lessee. The lessee oblique corporate debtor had not raised any amount from the lessor, that is Noida Authority, and therefore the lease would not fall within section 5(8)(f) of the IBC, even by a very stretched process of reasoning. So in this case, what had happened actually was that Noida Authority initially submitted its claim in Form B. They filed their claim as operational creditor for dues outstanding under their lease agreement with the CD. But subsequently, they revised their claim. They altered it. They filed in Form C and they said they are a financial creditor. So the NCLT held, and there was a considerable exchange of correspondence. Now, NCLT studied all of it and said, no, there is no financial lease in terms of the Indian accounting standards. And there is no financial debt as defined in section 5, subsection 8 of the IBC. So then Noida Authority preferred an appeal. The NCLAT affirmed the view taken by the NCLT, and hence the question reached the Supreme Court whether the lease executed by the Noida Authority in favor of the lessee, the corporate debtor, was a financial lease under section 58D or 58F of the IBC. I mean, whether it was financial debt in any manner by any stretched process of reasoning. And they also tried to fall back on the pioneer urban judgment of the Supreme Court. Now, this is quite a detailed judgment. It would make very interesting reading. Please do read it because the Supreme Court has dealt with the Indian accounting standards at length. Next slide. Now, what the Supreme Court observed was that, all right, Noida had leased out a plot of land for 90 years to the corporate debtor, but it was replete with restrictive clauses. One, that the lessee, builder, will construct residential buildings on it within 7 years. So construction to be made within 7 years, maximum extension 3 years, but with a penalty. Further, that if the lease were to be cancelled due to non-fulfillment of these conditions, that is construction within 7 years or within the extended period of 3 years, or non-payment of penalty or whatever, could be anything, then the land with any building constructed thereupon would have reverted to Noida Authority. Furthermore, that if the lessee were to wish to mortgage, it would need to take prior permission from the Noida Authority to create a mortgage. So it is not as if the lessee or the builder was free in any manner to do what it liked with the plot of land. The Supreme Court, after an elaborate process of reasoning and studying all these restrictive clauses and covenants, came and studying the accounting standards at length and the definition of financial or capital lease, said no, the lease was not in fact a financial or capital lease under section 58D of the IBC, read with paras 61 to 67 of the IAS, and would not qualify as a financial debt. Now, this I've excerpted from the Supreme Court judgment. A lease which is not a finance or a capital lease under section 58D may create a financial debt within the meaning of section 58F if, on its terms, the court concludes that it is a transaction under which any amount is raised having the commercial effect of borrowing. So they said, all right. And now let's consider first it dealt with, Supreme Court dealt with 58D and then said, all right, now let's see 58F. So the Supreme Court said, if the court concludes that it is a transaction under which any amount is raised having the commercial effect of borrowing, then all right, 5(8)(f) will be applicable. But in this case, the lease in question does not fall within the ambit of section 5(8)(f), as the lessee has not raised any amount from the appellant under the lease, which is a transaction. One falls within the definition of transaction, and the raising of the amount, which according to the appellant constitutes the financial debt, has not taken place in the form of any flow of funds from the appellant lessor in any manner to the lessee. The mere permission or facility of moratorium followed by staggered payment. Even if Noida Authority were to provide this facility of moratorium and say, all right, you can make staggered payments in easy installments, even that the Supreme Court held cannot lead us to the conclusion that any amount has been raised under the lease. Any amount has been raised under the lease. So this was the contention. That staggered payments actually means that, all right, a sort of a facility is being offered, which is tantamount to raising an amount under the lease. So Supreme Court said, no, we are not persuaded by this argument. So in view of this, the Supreme Court held that Noida Authority is not a financial creditor, but is an operational creditor under the provisions of the IBC. And of course, it was also noticed that they themselves had initially filed Form B, their claim in Form B, and subsequently altered it to a claim in Form C, and they tried their level best to contend that they were a financial creditor. So it's a very interesting case, since there's not a lot of law on this aspect. What is a financial lease, capital lease? So it deals exhaustively with this aspect. So here I finish my presentation. Like I told you, I have just taken some judgments. I've just taken whatever I found interesting and what I am currently dealing with, because there are actually many judgments on all kinds of aspects. So if you have any questions, please feel free to ask. Otherwise, we can conclude the session.
Ma'am, one thing, when you was deliberating,
yes,
there were 2-3 judgments in relation to acknowledgement of debt and proof regarding the financial debt. Somewhere it was stated that the agreement for financial debt is necessary. Somewhere Section 10 of the Contract Act was referred. Somewhere the court considered balance it as an acknowledgement to debt or something like in absence of the contract. So, but going through all these 2-3 judgments, as a IP, we sometimes get confused on what basis we need to consider the claim sometimes. Because
yes, I understand. I understand, where you are coming from, because there is a lot of discussion in these judgments. But let me just tell you what actually, you see.
One more thing I want to add in this is,
please.
You see, in normal circumstance, because our background is chartered accountant, in normal financial transaction, what happens is on yearly basis, there is a confirmation of accounts.
Yes.
The TDS is deducted on the interest portion of it, and the TDS is deducted under a specific section.
Yes.
Where interest is charged.
Yes.
Because there are different sections for charging or deducting TDS. For interest, there is a different section. For rent, there is a different section. So how come it can be argued that mere deduction of TDS and confirmation of accounts will not prove it to be the financial debt?
Okay. See, now the principal ground. Now I dealt with two judgments. One was the Banke Bihari judgment and one was the Pavan Kumar judgment.
Right.
See, the principal ground there was not really TDA, was not really this, that a financial contract will not involve any deduction of, I mean, a financial disbursal will not involve any deduction of TDS. No, that was not the contention. See, the principal contention was, how do you establish a financial contract?
Right.
There, the dispute was this, that a disbursal of money had taken place. See, in both cases, it was admitted that funds had been disbursed and substantial funds had been disbursed. What you see, what the parties in those cases tried to say was, a section 7 can be filed. A section 7 can be filed if there is a financial debt, and there can be a financial debt if there is a financial contract. See, just understand, leave aside TDS for a moment. You can file under section 7, section 9, section 10.
Right.
Now, a financial creditor can file under section 7. A financial creditor can file if there is a financial debt. If there is a financial debt, then there must be a financial contract. Now, the contention before the court basically was, the discussion before the court basically was principally this, that how do you establish financial contract? What was disputed was the existence of financial contract. In both cases, the disbursal of amount was accepted. Disbursal of amount was accepted by the respondent.
Now
They
the
said
question,
that-
one minute.
Yes.
As per your submission,
Yes.
is the under IBC, the existence of financial agreement is mandatory? That is the main question, you see, because
see,
otherwise also sometime by
Yes.
balance sheet, by confirmation of accounts, by TDS,
Yes.
even if that loan is on demand, there may be verbal kind of thing also. In
So
that
that is
case,
what the NCLAT has held. See, that is what the NCLAT has held in the second case. See, there has to be a contract. There has to be. There is an acknowledgement if there is a contract. See, understand, what is a contract? A contract is when two parties agree to something, when there is an arrangement between the parties. Don't take a contract as a very formalized thing. There has to be a contract even for an acknowledgement, for disbursal of amounts. Why will one party out of the blue disburse money to another one? There has to be some underlying arrangement. There has to be some underlying arrangement. And Section 3(1)(d) of the Application to Adjudicating Authority rules defines financial contract. And it says that in a financial contract, the terms of the contract must be revealed. Date of repayment, tenure, interest. Please see the definition in the Application to Adjudicating Authority rules. Therefore, in both these cases, in the first case, Pavan Kumar case, there was a disbursal. It was admitted that there was a disbursal. But what was said was that there is no contract. There is no contract. See, a disbursal can be for any reason. A disbursal can be for any reason. Now, unless there is a financial contract with terms that are specified, tenure, rate of interest, etc. That is what 3(1)(d) of Application to Adjudicating Authority rule says. There cannot be a financial contract unless all of this is there. And in Pavan Kumar's case, what was said was, yes, there is a disbursal, but there is no financial contract. And the NCLAT agreed. The NCLAT said there is nothing to establish the existence of the financial contract. See, financial contract is not merely acknowledgement in a balance sheet. It is not merely acknowledgement in a balance sheet. After all, there have to be some terms around the financial contract, a rate of interest, all of that, at least as per 3(1)(d) of the adjudicating authority rules. So in Pawan Kumar, the appeal was allowed, but in the later judgment, Banke Bihari, there the Supreme Court, the NCLAT went by the acknowledgement in the balance sheet for a different reason. Not only because it was an acknowledgement in the balance sheet, there Banke Bihari had said there has to be a written contract. Firstly, NCLAT said, where is the word written used? The word written is not used anywhere. 3(1)(d) is very clear. Yes, there has to be terms of contract, tenure of contract, date of repayment, everything. But the word written is not used. That is one thing the NCLAT said. And then NCLAT looked at the acknowledgement and the nature of the acknowledgement. NCLAT said it is a loan, unsecured loan, repayable on demand. So that in itself indicates that it was a loan agreement. It was a loan agreement, unsecured loan. And tenure, what is the tenure? Tenure is this, it is repayable on demand. So that is how they came to their conclusion.
I appreciate it, but
Yes.
my contention is something different here.
Yes.
My submission is ki at one judgment they are saying ki okay, written agreement is not necessary.
Yes.
Even oral agreement can do.
Yes.
That is the section 10 of the Contract Act says.
Yes.
So in other words, if you go by their deliberation,
Yes.
in one case they are accepting section 10 of the Contract Act. In the other case, they are rejecting it because the IBC is competent in itself. Something like that. In their own judgment.
No, they have not relied on section 10. They've relied on 3(1)(d) in both.
Yes. Yeah.
3(1)(d) of the application.
No, they specifically said that the IBC is itself
That is
a
said.
law,
That is said.
and we are so that's why we are not considering section 10 of the Contract.
That is right.
Something
and
like
they
that.
said 3(1)(d). Basically, what they've said is 3(1)(d) does not say that the financial contract has to be in writing. So they've said even 3(1)(d). In fact, in the discussion in this case, Banke Bihari case,
Right.
that, they had, during the arguments, they had said that actually 3(1)(d) is akin to 10. It doesn't say that the contract has to be in writing.
Right. My experience as an IP is
yes,
in most of the cases,
yes,
specifically for the unsecured loan, you see,
yes, yes,
the balance sheet will fully represent the matter.
yes,
What nature of loan is there or something, what you said, it was nomenclature unsecured, payable on demand or something like that. There is a confirmation of loan agreement, confirmation of accounts yearly. Interest is charged in that particular account. Naturally, you can recalculate and establish the rate of interest.
That's right.
You are being deducted TDS on account of certain under certain sections of the Income Tax Act, which clearly states that it is for the interest.
Yes.
Something like that. So even if there is a oral agreement, and if all the documents which are otherwise established on behalf of the corporate debtor is establishing the nature of the transaction, that is more important in my opinion.
No, I agree with you. In fact, that is what the NCLAT has also held. You see, in Banke Bihari, that is what the NCLAT has also held. I mean, they have arrived at a similar conclusion.
Right.
Now, so you see, you said, yes, as IPs, this challenge will be faced. I'm facing another challenge as a lawyer because we have a case.
In case of when we ask for the claim and when we ask further documentation from them, so they are giving references for different case laws, and this is not required. This is
I know that is happening quite a bit because you see, this is growing jurisprudence. This is growing jurisprudence.
Exactly.
So Now, in the case that I am mentioning, we will somehow have to establish before the NCLAT that even an oral financial contract does not exist. So our research there is going to be, how do you establish the existence or non-existence of an oral contract?
Oral contract. Very challenging.
Yes.
Thank you, ma'am. Thank you.
Thank you. Any other questions?
I would request participants to please ask questions if there are any.
Now or at a later date, you could share by cell number. Anybody that has any issue, please feel free to ask. Please feel free to ask. If you
Thank you,
don't
ma'am.
have
Thank you.
questions now, yes, if you don't have questions now, we can conclude the session, but you can always go back to the ICSI IIP and anytime you can revert to me. Yes.
Ma'am, on the behalf of ICSI IIP, I would like to thank you for sharing your experience in the starting of the session and delivering a detailed presentation on the judicial pronouncement. Thanks a lot, ma'am, and I hope you take care of your health. Thank you so much. And please take care, and thanks to all the participants as well. Thanks a lot, ma'am.
Okay. All right. I'll take leave.
Thank you, ma'am.
Bye-bye.
Bye, ma'am. Please take care. The next session, the next two sessions will take place on Monday and Tuesday. So I'll be sharing the PPTs once I receive it from men, and then we'll begin the next session on Monday at 2 o'clock.